we've already met, we'll pass introductions to it. Hope you had a good lunch. The question that we've chosen for this afternoon is question 1. And I'll read it. If there is a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. Do you agree or disagree with Justice Brennan's view of freedom of expression? Why? To what extent, if any, should public universities be able to prohibit expression on campus that may be considered harmful to other groups? And have recent U.S. Supreme Court decisions upheld the framers' commitment to freedom of speech? Why or why not?
Justice Brennan's statement reiterates a fundamental principle of free speech in America. We don't need the First Amendment to protect speech that everyone agrees with. Brandenburg v. Ohio set the high threshold for limiting political speech. While we understand that this can permit a wide range of terrible speech, we think the alternative, giving broader government power to limit speech, is more dangerous. The government can limit speech with time, place, and manner restrictions as established in Cox v. New Hampshire.
Symbolic speech is also highly protected, though the O'Brien standard is slightly less stringent than Brandenburg. This protection was established in Strongburg v. California and upheld in Texas v. Johnson and is extended to students in Tinker v. Des Moines. While the Tinker case famously stated that faculty and students, quote, do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gates, it allows limits on student speech that is likely to cause a substantial disruption or violate the rights of other students. In Massachusetts, the right is extended through Pyle v. South Hadley, where the Massachusetts Supreme Court stated that a substantial disruption must occur in order to limit speech. While Tinker aligns with the special responsibilities of public schools, it is not an appropriate standard for public universities.
Public universities should be held to the Brandenburg test when limiting student speech. This is because they are havens of higher learning and the ideal setting for the marketplace of ideas first theorized by John Stuart Mill. Universities, however, have no ability to limit students who use the heckler's veto in order to suppress controversial speakers. They can place restrictions on faculty and staff when they are performing their official duties as established in Garcetti v. Ceballos, but cannot when they are acting as private citizens as established in Pickering v. Board of Education. Additionally, they can punish students for speech that defames, slanders, or truly threatens others.
James Madison drafted the First Amendment based on language from existing state constitutions. First Amendment scholar David Hudson explained that the framers were particularly concerned with protecting political speech and debate. Thomas Jefferson was influenced by Enlightenment thinker Voltaire in his belief that reason could lead to social progress and that no authority should be immune to challenge. In his bill for religious freedom, Thomas Jefferson gave 4 reasons to protect speech, including that freedom of conscience was absolute, that free speech was necessary to hold representatives accountable and allow debate in a democratic government, free speech was necessary to discover the truth, and lastly, restrictions on speech can further minority oppression.
The ideas of Justice Brandeis in the earlier 20th century helped to amplify the ideas of the founders. In 1927, Justice Brandeis wrote about Jefferson's ideas in his concurrence in Whitney v. California, where he said, quote, if there be time to expose through discussion the falsehood and fallacies to avert the evil through education, the remedy to be applied is more speech, not enforced silence, end quote. Until 1925, when Gitlow v. New York incorporated the First Amendment to the states, there were few examples of the First Amendment actually protecting speech. Schenck v. U.S., In re Debs, and Abrams v. U.S. all showed the Supreme Court was willing to heavily limit speech during times of war, but Justice Brandeis began to articulate the counter-speech doctrine and marketplace of ideas seen today.
Recent cases like Lincoln v. Freed and T.S. v. Talladega School District do focus on issues of political speech and therefore connect to founding ideas. Other recent cases, including 303 Creative v. Alanis, Shurtleff v. Boston, and Mahoney v. BL, have certainly furthered the marketplace of ideas. These cases, focusing on wedding websites, religious flags, and offensive posts attacking coaches, do remove government from content discrimination and excessive regulation. But these cases also seem distant from the political nature of the principles Jefferson laid out in 1777.
Thank you. We're ready for your questions.
Thank you so much. Thank you for putting away your notes. I appreciated bringing up the Brandenburg test as it relates to universities. And I wanted to ask, especially here in Boston, protest has been limited with regard to Palestine. Universities have recommended students for protests related to that topic. And I'd like to ask how public universities should respond to protests that seek to prevent unpopular speech.
Well, public universities, as we said in our statement, are havens of higher learning. And their purpose is to promote education and further development of the young people's minds. So upholding this is very important, and the university should strive to do this.
What would you say the counter to that argument is? Why should it be infringed, or why should it be pressed back on?
I think the counter to this is that free speech is very important, and if the government or universities begin to overregulate, it can just lead to excessive regulation, and this is the opposite of what the founders wanted when they were coming from Britain, where their speech was basically not protected at all, and their political ideas could not be shared, and they were persecuted for this. So they wanted to protect free speech in order to prevent this from happening.
You mentioned a bunch of cases right there at the end, and I'd like to unpack a few. Lincoln v. Free, Talladega. Talk to me about some of those cases and why you felt they were worth bringing up.
Well, with TSV Talladega in 2016, a student wrote Trump 2016 on a whiteboard, and he was then suspended because of that. The teacher felt that there would be a substantial disruption that could have been caused following the Tinker Standard. And this was a major case because it just goes into political speech and limiting it in schools. And it shows that even with opposing opinions on either like political or ethnical, it can easily be limited in schools, which is why we should definitely extend more rights to students.
Yeah, in Lincoln v. Free, there was a government official who had a Facebook account, and his follower count ended up growing, so he made his account public, and LinkedIn found the account and commented on a post, and the government official ended up blocking LinkedIn, and LinkedIn sued, saying that this was a violation of his political speech because this was a government official. But the Supreme Court held that because this page wasn't there to actually act as the government, speaking for the government, that blocking LinkedIn could be allowed because of the because the LinkedIn is not a government official on his Facebook account. He's not representing the government.
Do you think that's the right answer, with as much as our identities in person and at work fuse with our identities online? Do you think the court got that right?
Yeah, I mean, just because he's a government official doesn't necessarily mean that anything he does is for the government. I think that allowing him to express his views in a way that anyone else on Facebook could is the right choice.
Does everyone agree with that? Okay.
Great reference to Voltaire and this idea that reason can lead us to truth, because truth is critically important. What do you think is more important, truth or freedom? Take your time.
It's a great question.
It's supposed to be an easy one.
I think with the marketplace of ideas, with having multiple opinions, which each people have their own freedoms to speak about, the truth can come in, so it could be a balance of both, having freedoms to speak and also being able to access the truth.
And that's absolutely right, but if you have to pick one,
I would argue for the freedom of speech because of what I previously mentioned with coming from Britain. The freedom is the most important part of why we became a country on our own separate from Britain. So upholding this is extremely important.
great.
I'd say I have to disagree with my colleague here. I feel like having access to the truth is what should be prioritized, because with things like defamation and libel, it could be not knowing like true stuff is very negative for your own like thoughts.
Yeah, and adding on to Brody, I also agree with him that truth is more important, just because you don't want someone to lie to you about something important, and you want to hear everyone's opinions, and you want it to be the truth.
Yeah, just kind of going back to what Brody originally said, it's having the right to say what your thoughts are usually will lead to your truth coming out, and then eventually this inherently will lead to the marketplace of ideas being upheld.
Thank you.
How does protection of speech relate to misinformation? information that is someone's truth but may not be factually correct.
Well, we can see in the case of Harness v. Illinois that defamation is not protected speech, and this is speech that is hurting someone's character and their public image, and this isn't protected because we need to uphold the truth found in the marketplace of ideas without hurting people, because our free speech isn't infinite. It can be restricted for specific purposes.
Also, with that, misinformation can start from one thing. If somebody gets one small fact wrong, then it'll be spread around and everybody will start to believe that that statement is true, even though it's not.
And adding on to Brody, an example of this could be in the case of Deputy Heard, when there was massive amounts of misinformation going around about Johnny Depp, and even I saw it on my phone, for example. Like, I would go through TikTok and I would see lots of jokes and memes around Amber Heard.
How have the political branches protected or failed to protect freedom of speech?
Can you please restate the question?
Yeah, how have the political branches of government either honored our freedoms of speech or dishonored them, failed to protect them? What examples come to mind?
Well, the main case, Brandenburg v. Ohio, that we mentioned in our statement is the principal case that is used today, and it has two prongs. Does the speech promote imminent lawless action, and is it likely to produce that action? And using this test, we can determine if speech is protected or not protected, because you can't just be telling people to break the law. It's not protected, and we have laws in order to uphold the social contract of our country. So speech that infringes on that is not protected speech.
Any other branches? We've got the court. What about like a don't say gay law in Florida? What do you think about that? Justified?
I think that's
Overreach?
I think that's an overreach of the responsibility of the government, because as I previously mentioned, if we start restricting things based on what the government's views are, then it can eventually lead to this over-restriction, which is the opposite of what the founders believed in.
We've got about 10 seconds, 20 seconds left. I'd ask a question in the last 16 seconds, but I don't think I will. Thank you very much.
Yeah.
Fantastic job. I really enjoyed hearing your opinions blend into case citations, specifically with bringing up Illinois' defamation case in relation to misinformation was a great poll. And bringing back to Deputy Heard is also a great poll. I really enjoyed bringing court cases back to answer the question and citing evidence. And also great work to take a breath, give the opportunity for the question to be restated. Only constructive criticism is to, lean in on your colleagues and what you all know. I appreciated that Logan spoke on his experience. Was it in Britain? Or your
No, it was just the founders.
Okay, thank you. I was like speaking from your experience and the knowledge that you harness and what you know, and being able to pass off if you don't know how to answer a question, knowing what your colleagues are strong in so that they can support you and you can collaborate.
Yeah, I think just comparing morning, I feel like you were definitely more passionate about the morning topic maybe than this one. So I felt like we had the same amount of evidence. You guys had a great number of cases, both in the follow-ups and in your prepared remarks. You did the same thing in the prepared remarks where you just teased a couple headlines and then you were ready for the follow-ups with the narrative of what the case was about and why it matters. So my feedback from earlier applies there too. But in this one, I think my recommendation for you would be to like maybe tease apart some of the actual on-campus disputes and like really get into it with each other and figure out how you feel so that you can bring forward some like of your own opinions on why this matters or doesn't matter. I think that'll just make it that much more persuasive because you guys definitely had a command of the knowledge, but I think a little bit more passion in what the issue that we were talking about would have taken you to that next level. But good job.
I agree entirely with my colleagues. I spent most of the presentation writing down what you were saying to remember it for later. The remedies more speech. That was brilliant. And the initial quote about we don't need the first to protect speech that everyone agrees with. That's exactly on point. But to your point a moment ago, you incorporated case law right into the conversation, and which was just perfect. And I've got the word wise written down here. It's a very wise presentation. Great work.